G'day everyone and welcome to video 3.2.6 from the Legal Studies Guy. Straight into it, our quote today is from Stephen Covey. I'm not a product of my circumstances, I am a product of my decisions. Look, pretty simple one. I think most of your teachers would be aware, and even you as kids would be aware of how easy it is to make excuses and the amount of excuses we sometimes hear. And unfortunately, it's a fact of life that we're all going through different things, and there's all different, everyone's got different circumstances that are holding them back, but you are always still in control of your decisions, and making sure you make the right decisions. And, some of you might be going through some pretty big stuff in year 12, I imagine, but for others, it might just be simply, do you make that decision to go to that party on the weekend, or do you make that decision to go out with friends or study, and those decisions are ultimately what's going to dictate how you go at the end of the year. As I said, 3.2.6, today we are looking at the reasons for a Victorian court hierarchy in determining civil cases. If we just took this as it is at that point, we'd be like, okay, what do we have to talk about? But luckily they give us the old including and tell us there are two things that we need to know. So we'll cover those two things in these slides. We will know why we have how administrative convenience in a court hierarchy are linked, and we will know how appeals in a court hierarchy are linked. And you may remember that from Area 3.1 when we did that for criminal law as well. Our key skill, explain the reasons for the Victorian court hierarchy in determining civil cases. So pretty straightforward. Our skill here is just explain, no need to discuss. Sorry, I'll bring that one back through. So no need to discuss, no need to do both sides, just explain. So our essential question, what are the reasons for a court hierarchy in civil disputes? Similar again the exact same as the criminal courts. The courts in the Victorian court hierarchy are in order of importance: the Magistrates Court, the County Court, the Supreme Court, the Court of Appeal, and the High Court at the top. Please note again, the jurisdictions of the Victorian courts is assumed knowledge. However, I will very, very quickly do this for you. Original jurisdictions on top. Any claims where the monetary value is under $100,000 will be dealt with by the Magistrates Courts. The County Court has an unlimited, remind me of that tomorrow. The County Court has an unlimited civil jurisdiction, as does the Supreme Court. And we know that they do not have original jurisdictions in the Court of Appeal or the High Court. So the County Court or the Supreme Court can hear any civil matter, and the Magistrates Court is restricted to matters under $100,000. The Magistrates Court has no civil appeal jurisdiction. The County Court has no civil appeal jurisdiction. Sorry, I'm getting in trouble here with my fat thumbs. The Supreme Court hears point of law from the Magistrates Court, and the Court of Appeal hears all appeals from the County Court and Supreme Court. And then the High Court can hear potentially some appeals from the Court of Appeal. So again, this is assumed knowledge, but it's important to note that if you are looking at a case study and the monetary value is quite low, thinking about where that dispute would be dealt with, if you're discussing whether it's more appropriate for the courts or for VCAT or something similar like that. So the study design dictates that we only need to know two reasons for having a court hierarchy, and they are number one, appeals, and number two, administrative convenience. Let's go into these two in a little bit more detail. Appeals, luckily, and that should be 3.2.11, is the same for civil as it is for criminal. So if you are dissatisfied with the results of your trial and there's grounds for you to appeal, you can go to a higher court for your matter to be heard by a more experienced judge. If there was no hierarchy, there would be no higher courts, and this wouldn't be able to happen. An example here is the Kevin and Jennifer case. It was initially heard in the family court, and we talked about this for 3.1.11 as well. We know that in the Kevin and Jennifer case, it was about whether Kevin could be considered a man for the purposes of the Marriage Act, as he was a post-operative transsexual male. The family court agreed that he did meet the definition of being a man, and the Attorney General at that time appealed this to the full court of the family court. They said, hey, I think this judge has made a mistake, and I would like more judges to look over it to be able to decide if a mistake was made. The full court of the family court upheld the decision, meaning they said no mistake was made, we've reviewed it, we think the decision was right, the decision was fair. Administrative convenience. This is somewhat a little bit like specialisation, in the sense of cases are streamed to different courts based on their complexity and their seriousness. This is all about time saving. So the main aspect of administrative convenience is the fact that effectively less complex or less serious cases, and we know they're less complex or less serious because these are all the matters that are under $100,000, are dealt with by the magistrate's court. It's more common to have disputes like that, and they might end up being dealt with by VCAT obviously, but these disputes of less than $100,000 are significantly more common. As we know, there are significantly more magistrates' courts and more magistrates in Victoria to deal with them, and therefore our senior courts can have time freed up to deal with more complex legal matters that require detailed and intense trials, because we know they take longer to hear, and they should be heard by judges who are experts. So this is the other aspect of administrative convenience, is each then senior court, and the magistrates court as well, is separated into different lists. Different lists focus on different things, like the commercial division focuses on commercial law, for example, and therefore, again, it allows things to run much more smoothly. Judges who are experienced can deal with matters quickly if they're experts, and therefore more cases can be heard. So administrative convenience is all about ensuring efficiency so more cases can be heard. Big links to access here. Look, as I said at the start, super simple skill here. We just need to explain the reasons for the Victorian court hierarchy. No discussion, no evaluation. So we're going to get questions as simple as this one. Say 2 marks. Outline one reason why a court hierarchy is used in civil disputes. So just one reason why we use a court hierarchy in civil disputes. And a simple answer could look something like this. One reason we have a court hierarchy in civil disputes is due to appeals. So we identify the reason. If one party is dissatisfied with the outcome of their case, believes that the law was applied incorrectly, or is unhappy with the remedy awarded, a hierarchy allows them to ask a higher court to review this. So building that understanding, as we show that you can appeal either on the outcome or the result, which is here. You can appeal on a point of law if you believe the law was applied incorrectly, or you can appeal based on the remedy awarded. We obviously need to work out if it meets the principles of justice or not, and I'm going to show you my opinion on that in 3, 2, 1. Pretty straightforward, really similar to the criminal stuff. So appeals allow fairness, because if you feel you weren't treated impartially, if you feel like the decision was made based on bias, prejudice, other factors other than the evidence itself, you can get that reviewed up the chain and make sure that fairness is recovered or reapplied to your trial. Also, administrative convenience ensures outcomes are fair, because we make sure people who are experienced with different matters hear them. Therefore, the decision that's made should be correct by someone who is an expert. That's fair. Everyone has the right to an appeal. If you feel like things haven't been equal, you can pursue it further. But not everyone has access to experienced judges. different disputes heard in different courts, particularly we're talking more minor matters that are maybe dealt with by magistrates, might result in a lack of equality. And the final one is, and I talked about this in a little bit more detail before, administrative convenience is all about being efficient. Getting the fat fingers again. Administrative convenience is all about being efficient, and we know efficiency is about resolving things quicker. As soon as you resolve things quicker, you allow for more disputes to be resolved, and therefore you're improving access. So you're allowing more people physical access to the court because you're resolving disputes in a more efficient way. However, appeals can add extra steps to a case. That makes it more financially difficult or stressful for an individual, meaning they might not be able to continue to pursue their case, which is a lack of access. And it also clogs up the court so that other people can't have their matters resolved. Synthesizing, looking at some scenarios, and I'll post these below. It's just a simple, go have a look at the county court or the magistrates court websites for their civil jurisdictions, a bit of detail about the lists, and you can get a bit more of an understanding of where that expertise and where that administrative convenience comes into it by having people who are able to resolve disputes efficiently. Can you answer our essential question? I really hope you can. Only a pretty quick one and a pretty straightforward one content-wise, and that's why we only needed about 12 minutes. What are the reasons for a court hierarchy in civil disputes? We know that that's appeals and administrative convenience, and now hopefully you can explain those. This has been another video for the Legal Studies Guy. Give us a review on Facebook. Make sure you subscribe on YouTube as we work our way through towards the end of area of study 2.